Hi. We were talking last week about auto accidents and so much more to say about that. We talked a little bit about property damage and making sure that if you're in an auto accident and the at-fault party isn't immediately stepping up, or their insurance company, to pay your claim, and you have collision on your policy, you have a duty to mitigate your damages. You have a duty to minimize your losses and use your own collision. That's okay to do. That's why you have it there. Your premiums don't go up. It's not a black mark against your insurance. They don't drop you. It's not a chargeable accident to you. Take your collision coverage, get your car repaired, and get your rental paid for, and your insurance company, they will be paid back by the other insurance company eventually. So if there's some delay in the adverse or the at-fault party paying you, it's okay to use your collision coverage. We do it every day. And that part of the claim gets completed almost immediately. The personal injury part of your claim is a separate portion. It comes out of a separate reserve or checkbook, if you will. So don't feel like once you sign a property damage release, the case is over. The personal injury part of the case usually takes a lot longer, and it is important that you seek your medical treatment immediately. Any lapse in coverage, an extended lapse in treatment will be a death blow to your case. I mean, it's important that there's a continuity of medical treatment from the day of the accident until you reach maximum medical improvement. Oftentimes people get in an auto accident and say, oh, I don't have health insurance, or I can't pay for a doctor, and they don't go for weeks and weeks, and they eventually call an attorney such as myself and say, I'm hurt, but I can't get to a doctor. Insurance companies will say, well, if you were so hurt, why'd you wait 3 weeks to go to the doctor? It's important to get that treatment as soon as you can, and a lawyer can help you do that. A good personal injury lawyer will have contacts with doctors that will work on a letter of protection where you can go get treated without paying them, and they'll get paid out of the case by our promise to pay them once the case settles or we obtain a verdict. Go get your medical treatment, and once you reach maximum medical improvement, then at that point, we would take whatever medicals you have, EMS, emergency room, your primary care physician, physical therapist, whatever you got, together with your out-of-pocket losses, over-the-counter meds, prescription receipts, lost wages, and we package that up into a settlement brochure that we send to the at-fault insurance company. It has a statement of facts, statement of liability, statement of damages, a statement of the law, and a demand for settlement. We send that to the insurance company. We give them 30 days to make an offer. 9 times out of 10, when liability is clear, they'll make an offer within the 30 days. And at that point, we would call you and say, listen, this is what they offered, this is what we think the case is worth, this is how much we think we can settle it for, and this is what you will net after everybody's been paid. We negotiate it up to top dollar. Once we have them tapped out, I can tell you to the penny what you're going to get after all the medical bills and lawyer fees and everything is paid. There's always enough money for the lawyers to get paid, the medicals to get paid, and leave you with the majority of the money. We don't let our clients walk out of here with less money than us. We think it's bad business. It doesn't look good when the lawyer got all the money, so we don't do that. At that point, if the amount of money is not enough, or you're not happy with that amount, we can sit back down and talk about arbitration, mediation, litigation. Up until then, we're not suing anybody. We're not going to court. We're not taking anybody home or suing anybody. All we're doing is processing a claim against a multi-million or multi-billion-dollar insurance company. The person that hit you, the at-fault party or the adverse, their premiums have already gone up. They have already been charged with the accident, and their premiums have jumped whether you make a claim for $1 or for policy limits. So don't feel like, oh, I don't want to bring a claim against the poor guy. He's out of the loop. All we're doing is going against this multi-million-dollar company. So if you want to try and save State Farm or Geico or Nationwide some money, that's up to you. But you should get the medical treatment that you deserve and that you need through processing a claim through an attorney such as the Clekus Law Firm. Thanks.